Delhi. Audio is coming. You are ready. सब फोन में देरी वाला सब रेडी प्रशांत प्रशांत सब रेडी
Today's event, I request everyone to kindly put Before commencing with today's event, I request everyone to kindly put their mobile devices on silent mode. Thank you. They say, create your own visual style. Let it be unique for yourself and yet identifiable to others. A very good morning to our esteemed dignitaries, students, and participants. My name is Sahesh Sharma, and I, on behalf of Maharashtra National Law University, Mumbai, wholeheartedly welcome you all to this one-day international workshop on copyright issues related to entertainment industry. This workshop is organized by Department for Promotion of Industry and Internal Trade, IPR Chair, Center for Research in Intellectual Property, NISHITH DESAI Associates, and Maharashtra National Law University, Mumbai. MNLU Mumbai is one of the premier national law universities located in the economic capital of India. It offers graduate, postgraduate, and research degrees in law and allied disciplines. The object of the university is to advance and disseminate legal learning and knowledge of law and legal processes and their role in national development. Department for Promotion of Industries and Internal Trade, Ministry of Commerce and Industry, Government of India, launched a scheme for pedagogy and research in IPR for holistic education and academia in the year 2016, under which IPR chairs have been set up in select universities and academic institutions. Our university was selected by the DPIIT as one of the 12 universities for setting up IPR chairs in the country. Center for Research in Intellectual Property. The center is aimed to lead research and promote well-informed interdisciplinary work in the area of intellectual property law, policy, and practice through rigorous academic research, the presence of high-quality researchers, and conducting seminars, workshops, and conferences. The center aims to bring together a group of legal academicians, policymakers, and industrialists. NISHITH DESAI Associates has earned a reputation as the Asia's most innovative law practice and the go-to firm for companies around the world that want to conduct and pursue litigation in India or vice versa. It is a research and strategy-driven international firm with offices in Mumbai, Palo Alto, Bangalore, Singapore, New Delhi, Munich, and New York. NDA has conceptualized and created a state-of-the-art blue sky thinking and research campus, Imaginarium Aligunjan, an international institution dedicated to a pre-mediated future with embedded strategic foresight capabilities. As we gather here today under the patron and guidance of such holistic institutions of learning and legal arena, let us begin this workshop by lighting of the ceremonial lamp. I now invite all the dignitaries to please join and set the tone of the event by lighting the lamp. I now request all the dignitaries to please be seated on the dais. I would now like to invite Professor Dr. Anil Variyat, Registrar, Maharashtra National Law University, Mumbai, to kindly address the gathering and deliver the welcome address.
Respected Chief Guest of the Day, Professor Dr. Tabriz Ahmed, Honorable Vice Chancellor, GD Goenka University, Professor Dr. Dilip Uke, our Vice Chancellor who is chairing the session, Dr. Dumane, IPR Chair, Professor Maharashtra National University, Srimati Gauri Gokhale, Partner, NISHITH DESAI Associates, my colleagues, Sri Sajid Sheikh, Tista Hans, other members of the faculty and staff, and all the dignitaries and the participants who are joined here today, this morning. A warm welcome to you all to Maharashtra National Law University, Mumbai, on behalf of the MNLU family. As you are aware, IPR has gained a lot of importance today, especially with the development of trade and industry, also on account of the technological development. And Maharashtra National University, as you're aware, we have a chair, IPR chair, established by DPIIT. And it's a matter of pleasure for us to inform you that MNLU Mumbai has received IP Excellence Award in Education Training in 2021 from World IP Forum. The credit goes to the IPR chair as well as the Center for Research in Intellectual Property Laws. And as an institution of excellence, we always believe in inclusive growth. And it is not possible for a young institution like us to develop in-house expertise in every branch of law. At the same time, we cannot be away from any area of knowledge. So we have collaborated with experts, expert institutions and organizations in different fields, so that academic excellence can be developed. And one of such association is with NISHITH DESAI Associates, which is, as you are aware, which is a law firm of international repute and international presence, not only in the field of IPR, but in almost every field of commercial law. That NDA has made a lot of research and contributions, and for last few years they are collaborating with us. And I see that this collaboration and this seminar, this conference, which is part of such collaboration, will lead to professional and academic collaboration. blending of professionalism in academics. And I congratulate the DPIIT chair, Maharashtra National Law University, and Center for Research in IP for taking such initiatives. With this, I would like to extend a hearty welcome to our chief guest of the day, Vice Chancellor Professor Tabriz Ahmad, who has invited our invitation, that was at a very short notice. And he has taken time out of his busy schedule to travel to Mumbai and be with us. So I welcome you, sir, on behalf of the Maharashtra National University. Then again, the present session is chaired by our own Vice Chancellor, Professor Dilip sir, who guides us in all endeavors of academic excellence and provides support and guidance. It is my, though he is the head of the family, it is my formality that I shall extend a welcome to sir. Sir, on behalf of the Maharashtra National Law University and all those participants present here, I extend a hearty welcome to you to this program. The representative of our knowledge partner today, Srimati Gauri Gokhale, she will be interacting with you in other sessions. But in advance, I extend a hearty welcome to her. Welcome you, madam. And Dr. W.M. Dumane, who had been our chair professor IPR here. Currently, he is director of the Center for Research in IP. He had been very active in organizing a lot of programs, and in this program also he has taken a lead role. So he is again member of our family, but still I owe that I should extend a welcome to sir. Welcome, sir. And other office bearers of the center and the chair are here. Sajish Sheikh, who is also Assistant Registrar Academics. Then the research assistants, Gunjan Deshpande, Purva Sharma, and the research scholar and coordinator of the chair, Tista Hands, members of our faculties and staff, and above all, the participants who have come here on a holiday to share your views also here and also to have interaction with the experts. Without your presence and support, such programs can never become a success. So on behalf of our Vice Chancellor, the members of the staff, and the entire MNLU family, I extend a hearty welcome to each one of you. And also, I wish this program a grand success. Thank you very much.
Thank you, sir. I now request Professor Dr. Dilip Uke, Vice Chancellor, Maharashtra National Law University, Mumbai, to kindly felicitate Dr. Tabriz Ahmad, Vice Chancellor of GD Goenka University and Dean School of Law, with sapling and a memento. I now request Professor Dr. Anil Paryad, Registrar, Maharashtra National Law University, Mumbai, to kindly felicitate Advocate Gauri Bhogle, head of TMT practices, Nishith Desai Associates, with a sapling and a memento. I would now like to invite Professor Dr. Dilip Uke, Vice Chancellor, Maharashtra National Law University, Mumbai, to kindly take over the podium and deliver the presidential address.
Thank you. A very happy and good morning to all of you. Chief guest of today's program, Professor Dr. Tabraj Ahmed, Vice Chancellor of GD Goenka University, the partner of NISHITH DESAI Associate, Ms. Gauri Gokhale, Registrar of the Maharashtra National University, Dr. MNLU, Coordinator of the Center of IPR, MNLU Mumbai, Dr. Dhumane, all other colleagues and dear participants who have joined online as well as offline. It gives me an immense pleasure and happiness to welcome you all once again. I've been talking to Professor Ahmad yesterday informally. He was inquiring about the university's inception as well as its journey till now. I said we are just 7 years old, a kid. Nevertheless, the 7-year-old kid has tried and trying to jump and scale the heights academically. We have not only BA honors degree course, LLM course, PhD program, but in addition to that, another 3 LLM programs, then MA, then MBA, then centers, near about 17, 18 centers. One amongst all is DPIIT and the Center of IPR. And hence, the centers as well as the chairs are not ideal. Rather, they are setting ideals. We do try always to contribute in some way to the societal development, imparting and disseminating knowledge in niche areas. And that's why, since your centers as well as expertise, though limited one, we have decided to launch a master's degree program in intellectual property rights from this academic year. It is MIPR, a master's degree in intellectual property rights. Already, along with these courses, master's as well as graduate courses, there are near about 8 diplomas interlinked. The diploma in again IPR. So though by birth we are new amongst all NLUs, yet ultimately his conclusion and remark was that though it is just 7-year-olds, nevertheless university is growing. Dear friends, today is the world of technology. Just yesterday we had a program on AI, fintech and metaverse. Probably you could have invited Professor Tabraj Ahmed even for that program. He's also a man of technology, sorry, and IPR issues as. In view of this, this international workshop in copyright issues relating to entertainment industry being jointly organized by Maharashtra National Law University in association with NISHITH DESAI Associates assumes a significance, assumes the importance. I know that media and entertainment industry containing vast and diverse set of industries is nearly universally the poster child of creative expression, information dissemination, and economic growth. The film industry alone loses 2.8 US billion in piracy revenue per year, and everybody is aware of the media and entertainment sector's fight and piracy. Over the last 3 decades, the Indian media and broadcasting industry have grown tremendously. Access to the latest technology and information has increased exponentially during the internet era, eliciting the public's creativity and producing a large number of original works. The development of technology has turned the way creators and the creative industry harnesses their unused potential to thrive in the digital age. Any IP regime should ensure that it promotes creativity and innovation. However, technological advancements are happening at a rapid pace and they share some common features. They operate at the intersection of radical scientific developments and real-world implementation. Furthermore, they are changing the way we communicate, solve problems, provide goods and services, create and do business. Even with the current Indian vision to bring IP laws at par with the global laws, infringement is on rise. Creative works such as film, storyline, music, artwork, and literary works need protection and piracy in the market. But nowadays, it is difficult to track infringers due to massive infringement via multiple platforms. Copyright piracy in the entertainment industry is a threat to artistic works and expressions. Laws need to evolve with technology. Absence of technology, agnostic laws in India is a big hurdle for the media and entertainment sector, which will have to keep pace with the digital sector booming, absence of data privacy laws, amongst all other issues. The general trend is for society to move towards digital and social transformation. The entertainment industry must take preventive measures to safeguard against the challenge faced by technological developments. Awareness is also a key to strengthen the copyright regime. Thus, significance should be given on the effective and efficient implementation of copyright laws in entertainment industry. For media and entertainment to thrive, the market must allow fair competition, opportunities for collaborations, and the ability to effectively monetize commercial property, much of which depends on strong intellectual property protection. And I believe that today's deliberations, cutting across the sessions, would be really beneficial and useful to all of you. Thank you so much.
Thank you, sir. I would now like to introduce Dr. Tabriz Ahmed, Vice Chancellor of GD Goenka University and Dean School of Law, to the podium. Prior to taking up the current role in May 2020, Sir has served in various academic and administrative positions. He is a prolific speaker on higher education systems, processes, multidisciplinary research, NEP, cyber laws, IPR, and energy laws. Sir is also the author of a pioneering book entitled Cyber Law, E-Commerce and M-Commerce, and has published more than 100 research papers in reputed journals, along with being an active blogger, YouTuber, and editor of various international journals. I request Sir to kindly address the August gathering and deliver the keynote address.
Good morning. Good morning. Okay, it's really great. Matter of great honors, prestige to be the chief guest in this very important function today. Let me thank Dr. Bouquet for inviting me in this program, and also let me welcome you all in this inaugural function. It's a great initiative by I think DPIIT and also MNLU plus associates joining together to provide the kind of training program to those who are having challenges in the industry. Because ultimately, if you talk about the IPR, the biggest thing is happening in the area of computer software or entertainment, film industry, music industry, and also rightly mentioned by Dr. UK that we are losing $2.8 billion every year. And this is not reducing. In fact, this number is growing every year because the way we are able to get more access to technology. Let me just see journey how we have grown because the problem started when we had the printing press. So before that, there was no problem to 16th century. Because just to copy something, you require to just sit down and go on writing a book. It take a lot of time, energy, so better not to write. But once we have printing press, it has given a lot of options to immediately do printing and then circulate. Then the real problem started once we had the when we had the internet came in 1960s in USA, and then it's grown like anything because up to 1968 to 80s, it was used only for different purposes in the USA. They're just trying to have the fast communication. But 80s debate started that how we can use the internet, not only for research, but also for the other purposes. And then we have seen how we have seen the model of e-commerce and m-commerce. We are trying to use this technology for the fast growth of trade and commerce. And in this process, we have to see how the growth of mobile also is very important. So in 1980s, we have just 1G technology, just to call somebody and then for any kind of communication. And then we have seen in 90, we have also started using the messaging system. But in 2000, there is a great challenge because we have 3G technology. The moment we have 3G, and then we have the internet, and at that time there was no law in the country up to 2000 because our law came only in 2000. So 95 to 2000, the period, 5-year period, so the heaven for all the kind of people who are doing piracy. Because at that time, the electronic records were not recorded as per the Evidence Act of 65B, but the IT Act has added. Now it is a record, so anybody now can produce any evidence in the court of law. Anybody violating anything in the electronic mode will be admissible evidence. Then we have seen that how in 2010 we have the 4G technology, because before 3G there was problem of streaming. A very slow speed was there, and then in 2000 the Reliance came with the CDMA technology, providing a lot of people free of cost mobile phone, and then on very small price. And then we have seen that how Reliance has changed the entire scenario. Reliance was giving the SIM card free of cost. And then we have tested the YouTube channel, tested the OTT platform, and then we realized that now we can really use this technology, mobile phone technology, and because of that, India has become the highest consumer of data in the world. And now everybody is looking for the country that how we are going to get this market. As for the 13 of the copyright mentioned 57, that copyright subsists in literary, dramatic, musical, artistic, sound films, and sound recording. But this area, the literary work, has grown like anything because we have seen the computer programs and also the softwares are falling in the category of the literary works. And then we have seen the challenge between the patenting law and also the copyright law, that a computer program with the kind of complete package can be a patent, but just to have the literary will not be a patent. And then we have seen difference in Indian law and US law. but ultimately it's a matter of the fair use. In the fair use, if anybody will try to have the reverse engineering on the software, and then he is not violating any kind of the copyright. It's a fair use. So anybody can get a source code, and then he can bring from the object code, and then he will be able to do a fair use. So this area is conflicting with the US law, because in this process, what was happening, all the Indian engineers, they were trying to have all the good programs made by the IT companies, and thus do kind of reverse engineering and produce a new software. This is not the original software, but at least trying to provide you all the works what you are expecting from a computer software. This shows that how we have to replan about the policy making about the computer software and these computer programs, because if you do a lot of very serious kind of regulation, it will be affecting the IT industry. And if you not do proper regulation, again, will be a lot of chaos in the system. So now the question is that what will be the policy making about the IT, computer software, internet technology, internet regulation? Is a very, very vast area, because we feel that internet regulation is a kind of the government regulation. No, it is run by a private body, ARPANET. They are running the internet, and mostly it is controlled by Americans till now, till today. So then there's a group in the world. One is led by the India, China, Russia group. Other is US and other these groups. But America is not ready to come forward to have the proper terms, because IPv6 is now the current tech running for the internet, and it is controlled by the kind of US till now. That's why during pandemic there was a lot of hue and cry that whether the pandemic was man-made, planned, the business aspect, or it was a natural phenomena. Till now it is not clear. Why? What happened? Because the pandemic came in China and they settled down. Now this going throughout the world. When the world was suffering challenges, China was settled. And what happened? Because of that, IT share price was going very fast down, and all the Chinese companies, they purchased major shares in the IT companies. So now today what is happening? All the Chinese businessmen are the market leaders in IT, because they have the major shares in the IT. And then America is now struggling. So the point is that because now, unless until we really control, regulate the internet, we can never solve this problem of the violation of the content. Film industry cannot really get relief, because it is start happening mostly on the internet. When there was no social media, there was no DVD player, there was no kind of the pen drive. It was not very easy to copy and share. Now, because these technologies, is very easy to have the very good quality, and very in a few seconds you can share throughout the world. So anybody can get kind of the some film. We can share on the social media, and this person has a lot of kind of the friends. So friends. So within a few minutes, the entire thing can be flowing throughout the world. And if you catch the real person who has uploaded the film or song, even if you remove from his kind of the server, it will be already flown throughout the world, and you cannot ever control that how you're going to pirate the kind of this particular thing. So now point is that how we are going to really control this piracy, because we have seen in 2000 what happened when the P2P file sharing started, Napster case. So Napster was the kind of real challenge at that time, because P2P file sharing, what is happening that anybody will be downloading the software, and then software provides central database. Anybody will go to central database and download any song. So in that case, all those music companies will be losing money, because there is no need to buy from the original music composer song company. Just go to Napster and then you can download the song. This way, they were violating the system. Then again, case was filed in American Supreme Court, and then it was against the Napster. It was shut down. Now then we have Kaza technology, we have Grosser technology. So every time you are trying to control technology, it will try to find out the new kind of the problems for us. So the challenge is that we as a policy maker, as a lawmaker, have challenge to keep pace with the technology. And then again, even if you make the technology, make the law to regulate, the challenge is global. Because we as an Indian, we can make law for the country, but because the platform is global, and currently there is no global law on the IPR. We are mostly governed by those who signed WTO. They are run by the TRIPS agreement. And TRIPS again saying in 2073B that every country has a sui generis model, they can make law as per their own country. We have the plant variety laws on that model. We never signed the Farmers' Right Acts because we have gone by this, our separate law. So the point is that unless globally we have some regulation model, we cannot control the piracy of the music or films. So the next problem we have seen, then we have seen the kind of the OTT platform in 2010. And what happened that in the 11 IPL, it was on the OTT form. And in the OTT, it has given the very fast violation of all these music, all these film, the categories, because if you see how the power of communication was shifted from very controlled model. If you see in the in early childhood days, to get a telephone connection will be challenge. Only if anybody is MP or doctor, influential person will be getting the telephone connection, and forget the ISD call or STD call. You may get a local telephone connection. It was a very costly affair to get call plus pay. So when the mobile came in 1995, it was 9 rupees per minute call. Even if you receive the call, pay at least 4.5 rupees per call. But what happened now? Now the entire power of communication shifted from very controlled model, very regulated model, to a generalized model. Now anybody from anywhere can use mobile phones without any license. And it means that what was very controlled, the model was there in communication, now shifted to everybody, even rickshaw puller, okay, sabzi wala, dhobi wala, anybody can have mobile phone. It means that he has power to violate this any kind of the IPR work, any content, and then he is subject to also any kind of the piracy throughout the world. So in this model, because we shifted from the control model to fully liberalized model, and this is a big challenge right now, how to control. At least if you go for the television and film, there was some regulation was there. We have the regulation for the TV, cable television, the film certification board. But what is happening about the OTT form? In OTT, anybody can upload anything. But currently now, government has given the kind of the guidelines that even this platform can also be regulated. Now there is a big challenge that there are two groups. One group is saying that we should also enjoy our right to freedom of speech and expression. The right to press is there. If you also control this particular platform, then we are going to suppress the creativity. If you see the entire idea of IPR, it says that everybody has a right to do a lot of analysis, right to criticize, a right to do creative work, plus he has a right to experiment something. He can use all the platform for the kind of the use for the academics. Judges can use in the court of law for writing judgments, and parliamentary can discuss in the parliament for any kind of bringing new laws. But what is happening right now, because of the technology, now the technology companies, they're fully trying to control their content. If you go to any library, you can access any books. But if you go to any online journals, you cannot access all the online journals. Even you cannot access your own book, because it is fully controlled model. And that's why we have some DMCA in 1996 in USA. They have the anti-circumvention provisions. So anybody will circumvent any kind of control system on the internet, he will be liable. And we have seen Adobe case, that how somebody has developed a kind of the pirate software, and then he was trying to break the kind of Adobe system. Anybody can then start getting the content. It's a big challenge. So anybody is producing any kind of technology to anti-circumvent will be liable for that period. And that's why we in the country, we have to make a very strong laws. But the challenge is that already we have convergence model, but we are not having convergence laws. Still, we are having Telegraph Act 1885 valid. We have Wireless Telegraphy Act, we have Telegraph Act, we have Cable Telecommunication Act, we have also IT Act 2000. So all these laws are trying to regulate the entire internet separately. But actually, in 1995, already we have converged. We have one mobile phone which has everything. It has program, it has the content, it has the kind of TV connection, it has song. You can also communicate. You have the social media, you have internet, email, everything is there, but there is no convergence law. That's why in 2000 we had a bill in the parliament, Communication Bill 2000, but that bill could not survive because nobody was there to really frame a very strong law. keeping in mind interest of everybody, because there is strong lobby of the IT groups. They always want a free hand. So we as a lawyer, if we make laws, regulate them, they will always feel threatened, because they feel that if it is fully regulated, it cannot freely flow. For example, if you want to control the cyber crimes, very simple. Anybody who want to have the email address, he has to have electronic signature. He has to just sync with the his kind of the Aadhaar card, and then once it is verified, then only he will be able to open an email account. And same way on social media, anybody want to have social media account, he has to be verified properly. And once you verify, because right now what's happening, 50% accounts are fake on social media. Even one person have 4 or 5 accounts. Okay, one is using fairly for family persons, one using for friends group. Okay, one using for some kind of cheating and frauds. So everybody has 3, 4 accounts, and sometimes all the kids, because it is not verified by the technology that whether you are 10 years, 12 years, 14 years. As a law of the contract, you have right to contract only if you are major, 18 years age. But see, in social media, how many kids are there? Kids are buying from the Amazon, okay, all these items, how they can buy? Just to buy anything, you should have the age of majority. But now technology is not very, very foolproof, because we have ourselves given the free hand, because we want the fast growth of internet, fast growth of technology. That's why technically we are saying we are losing money, we are losing because the piracy are not happening, but we are ourselves not regulating. Same is for the encryption. If you remember the BlackBerry mobile phone, if anybody remember earlier, it was hot cake in 2000. Your BlackBerry mobile phone you are having. Why? Because safest mobile phone. Server was in USA, and then 256 was the encryption level, very high level. But the problem was that if anybody, because there was a case in the country, somebody was doing some anti-social activities, anti-India activities on the BlackBerry phone. When the police has caught the mobile phone, they could not recover anything what is there inside the phone, because server was in USA and it was very high encrypted mobile phone. How our local police, Thana wala will be able to open and crack the encryption? That's why there is a policy in the world right now that what at the global level, how much we are able to provide the encryption. Currently, only banks are allowed very high level security. Other companies are allowed to have very local kind of security. So sometimes we are saying anybody can open the mobile, the Gmail account, anybody can open the social media accounts, okay? Or anybody can do any surfing on the internet. Anybody now can upload anything. People are just going, cutting and pasting some music, some film scene somewhere and making OTT platform and uploading. What happened during the pandemic? We have seen how people have taken the photographs from the burning bodies from the hospitals, lack of gas, oxygen and all, and it has made havoc for everybody. Somebody was doing politics just to create a lot of havoc, and somebody was genuinely showcasing their anger because government could not provide oxygen to their parents, to their family, and that's why it was really making very serious kind of the problem. And it all come to the internet regulation, because if you regulate properly internet and if you regulate about the content, because content is big challenge. If you remember 30 years back, it was only 8-hour TV shows. Nowadays content, after 8 hours, every 8 hours it is repeated. So one show you can see 3 times in 24 hours because there is no content. They go on repeating the same content. But at least nowadays content is there. But content quality, who is the owner? Who should get the royalties? Who should be taking the kind of the permissions? If you know the Google case, so Google has done a great at least job. What they have done, they converted all the old books and in the at least giving on the Google. But what they have done wrong, they could not take in the license because sometimes difficult to find out that who is the whether author is living or author has dead. If author has dead, who is the next person? Because the law says life plus 60 years. If the parents will die, the kids will get 60 years. And in some cases, they could not find the real owner and they uploaded those books on Google. But later on, when the kids have seen the books are flowing, they filed a case against Google, and then a lot of issues were there, and ultimately it was settled. And see about the problem is coming now because of the AI. Okay. So AI is not a new thing, because we have seen pen paper case in 1991 when somebody has written a very good poet by the pen, and then somebody violated. The issue was that whether who will get the copyright, whether pen will get a copyright, or the person who was writing good poem, the poet will get the copyright, and it was challenged. So it was held that no, because pen has no role to play in the expression. Expression was coming from the author. So author will get a copyright. Same thing is coming by AI. Now AI has become so advanced, some of the AI generated works are more superior than human work. Now the question is that who should be getting the copyright, whether AI will get or AI's creator will get. Okay, so same thing we can apply. That pen paper case, we can say that no, it is the person who has ownership of the AI will be getting the copyright. Now the question is that this AI may also doing infringements. AI can gather a lot of data and then analyze and bring a new data set. This is not original data. It is just amalgamation of the old data in a new format. And then all those persons whose rights are violated to make new data, whether they can file suit against the AI or the person who was making the AI. But as per the policy of the IPR, only a human being will be holding the IPR. Non-human cannot hold the IPR. We have seen the 2012 in the US that you know the chimpanzee case. One famous photographer went to a jungle and he was moving in the jungle. One chimpanzee came taking the camera, and chimpanzee went to the highest peak of the plants and clicked several photographs. Later on, that photographer taken those photographs and uploaded on the website, and people started copying. Then he filed a suit that nobody can copy because I am the copyright holder. People said no. Photos are taken by chimpanzee. How you can hold the copyright? Then he said, because I am the cameraman. Camera belongs to me. I am the camera owner. So I will be getting the copyrights. So ultimately the court was not able to decide the case, and it was outside court settlement. Even today, 25% are going to that particular center who are actually having the ownership of the jungle, and 75% is going to this cameraman. Okay. Now the big challenge is that how to solve. So 2 years back, the WIPO has given a white paper and asking the kind of the feedback from throughout the world. Please give your kind of the feedback whether we can shift from giving ownership to the person to the non-humans. See what will happen. If a non-human will get an IPR, what will happen? It is going to challenge the whole philosophy of IPR, because IPR is for what? All those creators, inventors, investors should get a IPR or copyright if it is a contributory work, and after some time it will go to public at large. It's a balancing model. It's a balancing model, because nobody can create 100%. If you create something, you have taken from several sources. So how you can get 100% protection, just like intellectual property, because there is no time bound. But all the IPRs are time bound, because nobody can create 100% IPR. You have taken from society, from your friends, your faculty, your teachers, your university. So that's why you should try to get back from that what you invested. After that, you should give to society at large, so the price will go down. Society at large will get the benefits. That's why we are able to get the low price drugs right now, those who cross the parenting period. But if you then again go back and start saying that it is going to given the AI, what will happen? Those who are AI creators become billionaires. It will be challenging the entire sets. So now we are in a very challenging situation. One decision, if you take, will be going to impact the entire impact of the IPR. Another problem started because of the 5G in 2020. So 2020 is a big challenge, because we have at least we are able to have the 5G plus pandemic. So 5G plus pandemic has really made a kind of the serious impact. because of 5G, now the lot of data flow is there. In the 4G, we have towers at the 7 kilometers. In the 5G, every 250 meters, access points are there. And here two-way traffic, and that's why it is going to provide a lot of options to the autonomous cars. And then we have the other benefits, and then entire thing is coming in the data regulations. And because of pandemic, when shifted on the internet, there are more data generated. Okay, and then after that, we are able to see the big challenge because of the metaverse. So 5G, pandemic, and metaverse. Now in the metaverse, you can create your avatars and you can buy the places. And those avatars can also try to showcase a lot of things. And those who are getting the place on the metaverse, you can buy the space and also you can create a lot of items. In those creation process, you may also copy from different sources. Now the question is there, who will be liable for that? What is the liability? What is the place? What is jurisdiction? Okay. So all these are coming up. I think in this we have a lot of sessions today, and also we have a lot of good speakers. It will be a great chance for all of you to do a discussion and find out the solutions. With these words, I thank you all for patient hearing, and also let me thank for inviting me in this program and wish you all the best. Thank you.
Thank you, sir. I shall now invite Dr. W.N. Dumane, Director, Center for Research in Intellectual Property, MNLU Mumbai, to kindly extend the vote of thanks.
Respected Vice Chancellors, Dr. OK sir and Dr. Dobre sir, below Registrar, Madam Rory Gokhale from DESAI Associates, my colleagues. I am very much delighted to be a part of this important international workshop as our organizers team. And then it is my privilege to give the vote of thanks. As you are aware, the artistic creations in the form of creations in film, televisions, and then advertisement, music, etc., have seen a sea change, and these are used in media and industry. These creations and the copyright protection have been evolving with times, and nowadays, because of new technology, innovations, and new concepts, we are witnessing the sea of change in all this media in terms of scope of artistic creations and nature of these artistic creations. Particularly in the field of digital applications, online contents, AI, IoT, PC games, OTT, etc., as very aptly described by our guest speaker. However, what is happening? We find that the present provisions under copyright law are not enough or inept to take care of all these contents for copyright protections and safeguarding the interest of creators of this artistic work. Therefore, there is urgent need to discuss these issues and find the remedies so that the interest of creators and authors and the stakeholders are duly taken care of. Keeping this in view, the present workshop is organized jointly by MNLU and DESAI Associates, and we have been we are fortunate that we have got very expert, eminent guest today. That is Dr. Ahmad. And we have also got very expert panelists here to discuss all these issues. With this, on behalf of the organizers, I extend our deepest gratitude to Professor Dr. Tabriz Ahmad, our chief guest, for making his presence today and delivering
thought-provoking keynote address. He has touched many issues which are relevant to this workshop and has really given us insight how to proceed during the day. We extend our sincere thanks to our Vice Chancellor, Professor Dr. Dilip Uke, for his vision for this workshop and constant support, and delivering a prescient address, which was also encouraging. We also thank Dr. Anil, Registrar MNLU Mumbai, for his opening remarks and his guidance and support for this workshop. Also, it is my duty to thank Ms. Gauri Gokhale, partner MDA, for her support and partnership, and her team from NDA. We expect to have a very fruitful discussion during the day ahead. MNLU Mumbai once again welcomes all the dignitaries and participants, and hope for the fruitful discussions during this workshop. Thank you.
Thank you, sir. We shall now commence with the first session of today's workshop in 1 minute. Let us now proceed with our first session for today's workshop, which is based on the theme Copyright in the Age of Remake and Adaptations. It gives me immense pleasure to introduce you all to our panel for today's session. Advocate Gauri Gokhale, a practicing lawyer, Advocate Gauri Gokhale, practicing lawyer at TMT NISHITH DESAI Advocates. We also have the pleasure of having Dr. Birendra Saraf, Senior Counsel, practicing at the Bombay High Court. Next, we have on the panel Mr. Anil Lale, General Counsel, Viacom 18, who is a lawyer by profession and a postgraduate in media laws from the National Academy of Legal Studies and Research. And last but not the least, Mrs. Pooja Kapadia, Head of Business and Legal Affairs, Tulsia Media Private Limited. On this note, without further ado, I now hand over the podium to Advocate Gauri Gokhale to lead the discussion forward and engage with our esteemed resource persons on the panel. Over to you, ma'am.
May I now the panel on the stage, please? Thank you, first of all, agreeing to join the panel just with one message. We really appreciate your time. Yeah. So let me, this is Dr. Saraf, has some engagement. He needs to leave by 12:30. So what I'm going to do is first, let's, just do a little warm up on some of the key basic issues. And then I'm going to request Dr. Saraf to give his exposition on the theme. I think the one of the important aspects that we often encounter when we do any deals or we are engaging into any litigation is the identification of the ownership. I think in the earlier discussion there was a question as to what happens as who is the owner in relation or who is the author in relation to the computer generated work. Interestingly, our Copyright Act already answers that in 2D of the Copyright Act. So whoever is interested can quickly look at that. But my first question to the panel members and Dr. Saraf and Anil, to you first, is when you are looking at any transaction or litigation in terms of identification of the word, unlike the US where most people go register copyright. I mean, in India it's not compulsory, but in US you do have benefit of treble damages if you register copyright, right? So in India, there is no such incentive. And then we have Screenwriters Association, which is more of a practical aspect where people go register. So what are your, takeaways as to whether we should develop some mechanism? And just to give you a quick background, in one of the conversations which Sir also had attended, Justice Pratibha Singh, in fact, had recommended that should we in India create some kind of a registry to identify the ownership. So your thoughts on what are the current issues being faced and what are the takeaways from you? First, Dr. Saraf, if you want to quickly address that.
You're absolutely right that India does require a kind of a registry to register the copyright of various people involved in particularly the entertainment industry. It starts with maybe a story, a script, a story particularly. And as Gauri said, as of now, we at the highest have a very, very fluid situation of a person going and registering his story or script with the Screenwriters Association. But most often than not, what happens is there is a complete lack of awareness as to what is the copyright and in whom it vests. And there is no means of finding that out except for that one public notice which we issue in a trade magazine, to which most of the people answer is that I didn't notice it. And particularly if you come down to script writers, etc., they don't sit and read public notices everywhere. We had a very interesting case where in one of the matters, a lady who was the producer of a film went about creating multiple agreements in favor of different parties. So whenever she would leave money, she would go and execute an assignment agreement, say, giving satellite right to someone. 10 days later, she would execute another agreement for the satellite rights in favor of someone else. And how does the second person know that she's already created these rights in favor of someone? So it's extremely important that we have a very organized system of registration, which will also maintain confidentiality, because particularly if we talk of a script, a story, the registration thereof should have a great deal of confidentiality involved, because that should not be accessible to the public. So, and the difficulty also comes from a situation that a story is a very fluid thing at times. We may have named it something else. So how do you identify and find out as to whether that same story is registered or not? But particularly once a film has come into existence, then it can be much more crystallized. Who holds the satellite rights? Who holds the OTT rights? Who holds the theatrical rights? Each of those aspects should be available on a platform at a click of a button, where people, before entering into an agreement, can see that this is the right already created. And that is a great requirement in the entertainment industry today, because most of the litigation which emanates is from multiple agreements. It reminds me of the old time, where registration of documents used to take 8 years, 10 years. And in the meanwhile, people used to rampantly create rights. Now, today, the situation is this, that once a document is registered in respect of an immovable property, in the evening, it is uploaded on the website. We should surely arrive at such a situation. So far as commercial understandings are concerned, there could be easily a methodology of redacting that, so that people's commercial understanding, the money which they are paying for a particular rights, etc., are not disclosed to the competitors. So they can have so many ways of protecting that, but that is surely a very urgent and emergent need in India to protect copyright.
Anil, your take.
Yeah. So I completely identify with what Dr. Saraf just mentioned. A lot of disputes arise from rights being, there are double sale of rights that happens, and all those issues that comes into litigation. Regarding the registration of rights, yes, when you look at original literary work, musical work, and all those things, the registration is comparatively easier because it's an ownership that gets registered. But when we get into the domain of exploitation, I'm talking purely from a practical perspective of handling such rights on a day-to-day basis. What happens is that, let's say, a cinematographer, it has ownership as a work under Copyright Act. But when it comes into a studio or a broadcaster or an OTT platform like ours, what happens is that this gets bifurcated there are a lot of strands that emanates from one particular cinematograph film, which is capable of exploitation through various platforms. Let me give you an example. Satellite rights. When you talk about satellite rights, it's one part of a whole genus called linear rights. So when you have a cinematograph film, it can be transmitted through satellite, it can be transmitted through cable, it can go on OTT platform, it can go through an IPTV platform. So each of this becomes different various rights. Similarly, on demand, when you take the same cinematograph film and put as on demand is a common term used for when you demand and when you get it. But the commercial model of exploitation of that also includes SVOD, which is subscription video on demand, AVOD, which is advertisement video on demand, TVOD, which is transactional video on demand. These are all different rights again. So, and these rights keep on, changing hands. As in, let's say Wacom 18 Motion Picture Studio, we engage a production house to produce a movie. The first owner as a producer maybe or we acquire a movie, so the producer may be the first owner. Then all the rights or some of the rights gets transferred to us. Then we sell S4 rights to, let's say, Netflix. Then we sell TiVo rights maybe to an Apple. So this is a very it's a day-to-day business scenario here we are talking about. So we have an internal RMS system, which is rights management system, which has around 290 different bifurcation of rights from a single cinematograph film. So a public database, if we are to establish something like this, will it be capable of handling such a complicated rights management? Because when we are talking about registration here, it is straying slightly away from rights, registration of rights and getting into rights management, because every subsequent owner also has to be registered. So we'll need to think through all these complexities before we implement it as a law, saying that if you have a particular right, it needs to be registered, or it has some issue. It will have some issue with the ownership of that right, because then it affects the day-to-day process of business also. But at the same time, yes, if there is a original literary work, dramatic work, the whole ownership of a cinematograph film per se, to trace the rights to the original owner, there can be a database for that purpose. That obviously would be a great idea.
Right. So I think there have been discussions for, such as use of blockchain and all of that. So maybe that is something the DPIIT cell here can take a note, as both the arguing council as well as the industry feels the need for that, and maybe that is something we can add as our recommendation as well. I think the next point is which I'm going to request Dr. Saraf first to give your perspective on when we always say idea versus expression dichotomy, and then when we talk about inspiration, when we talk about incidental use, as also the concepts of remake, because none of these are defined in the Copyright Act, right? All these are contractual based. When you say derivative work, that is not defined. It's an adaptation that is defined, but in a different context. We also have concepts of franchise now being developed. When you have you saw the Singham franchise, right? Then you have spin-offs. So many new concepts are coming up. So Dr. Saraf, first over to you. When we talk about the first aspect is inspiration, incidental use, and then look at section 52, whether that adequately addresses, or how do we look at that, whether there is infringement, no infringement, what are the case laws saying? And secondly, on remakes, etc., how has the case law evolved outside the Copyright Act, and whether you believe that that is a good way to handle the situation, right, other than rather than making amendments to the Copyright Act to bring these concepts. So if you can give your perspective on these, and then I'll move on to Anil and Pooja.
So basically, they say imitation is the best form of flattery, but may not be so true so far as the entertainment industry and copyright rights go. So we faced a very developing kind of regime in India, and according to me, the Copyright Act, so far as cinematographic films are concerned, has a lot of lacunas which need to be redressed. It's interesting because though adaptation is defined in the Act, and if you take literary work, it speaks of an adaptation into a dramatic work, cinematographic film, etc. But if you take section 14 and consider the copyright in a film, it doesn't talk of an adaptation at all. It doesn't give an exclusive right to an owner to adapt. So why is that so? Because maybe that was not a situation which arose at a given time. So 14, I find, requires, so far as cinematographic film is concerned, surely a much wider protection, a wider network. And it is this lacuna in the language of section 14, which led to a rather odd judgment of the Bombay High Court in the case of Leo Brunet, which said that a copyright in a film is infringed only if a physical copy is made of the film or something like that. Now, that judgment was governing the field for a long time. It is recently that a full bench of the Delhi High Court in an MRF judgment ended up saying that no, that's not a correct exposition of law, because when it uses the word copy, it doesn't mean a physical copy all the time. A copy has a wider connotation in light of the Berne Convention, etc. So we need to, I feel, have a situation whereby the copyright in a cinematographic film is expanded, but it should not be expanded in a manner which is too well defined, because as much as human originality knows no bound, the ability of a human being to copy also knows no bound. So we must keep that definition wide enough so that ultimately it is a perception of a code which can fall in one of the categories. Because ultimately, what is an adaptation? The origin of adaptation has been very late in the Copyright Acts all over the world earlier. Adaptation or derivative rights were not protected at all. In fact, in cases of books also, even translations were not protected. They said that a owner doesn't have an exclusive right to translate the books. It is much later in the 1900s that the statutes amended to bring about a copyright in the Derivative Act. But so far as films are concerned, as you all know, the locus classicus in India is that R.G. Anand judgment, which says what is effectively a copy of a film or an adaptation of a drama or theatre into a film. It said that if ultimately a man sitting there in the theatre or a film thinks that I've seen this somewhere and recollects the central theme of which he feels, it leaves him with an impression that this is copied. So you have to ultimately take the two works as a whole, compare them as a whole, and see what is the copying, what is the extent of copying, what is the central theme, is the expression copied. Now that is a task which has to be ultimately left to a court of law. But my experience has been, and that's unfortunate, that we do so many matters relating to maybe infringement of a copyright in a film, but I've rarely come across an occasion where the judge has taken the trouble of watching both the works. Most of the times, the judge just sees two charts. What are the similarities? What are the dissimilarities? But most of the courts say that is the last way to analyze a film. You cannot dissect a film, say these are similar, these are dissimilar. You have to have an overall feel, an overall impression of both the works together. So therefore, the difficulty that our courts are facing, because of course, constraints of time, I don't fault them for that, is that the court has no time to see the two works. And if the courts cannot see the two works together, then it's a very difficult decision to arrive at. It's just ultimately the look and feel of what the lawyers present as the film. So the film loses and we create a film in front of the judge, which is not a fair thing. It is the author, the producer, the director's work which should be seen by the judge. Here I create a film in front of the court. And very often I find that original work is laughed at by us lawyers sometimes. I'm more of a producer's lawyer. So very often, we just say, what is there? Isn't it a regular day-to-day life? But everything is day-to-day life. Every original work has some basis in a social framework. As they say, the difference between a film and a book is that when you read a book, you create your own imagination. When you see a film, you are seeing the imagination of a particular person. So, therefore, the difference is in how you have imagined it, how you have expressed it. If the same book is created into a film by 4 different people, which has been done in the past, it could be done in 4 absolutely different ways. And that expression is something which ultimately a judge should appreciate. The character, the way in which the character carries, it will be amazing that in India today, we have so few judgments on a copyright in a character. There is very few judgments, but ultimately today, what was Sholay? Sholay was a dacoit in Chambal. So many films are made in it, but ultimately it was that character of Gabbar Singh which created that film, that expression of that man, of how it will go about the unfolding of the scenes. Now that is where we need to appreciate where an adaptation comes from, where a remake is a very different concept, but adaptation is a very fluid concept. You need to understand whether the heart, the soul, and the core of that movie has been copied by someone. Something which is so essential to that movie has been copied by someone. And that can be done only by a third-party neutral person who steps down, not from his intellectual, expertise of doing a super dissection, but similar to what I would say in a trademark analysis of an average man with an imperfect recollection of a common cinegoer, what will he think? And that is where ultimately a test of a court lies. But you surely cannot do that without doing an analysis of both the films together. So far as remakes are concerned, there we are facing a rather different and odd kind of a situation. Remake is usually understood largely as almost a scene-by-scene remake of that film. Recent thing is Drishyam, which has come as a remake. Now, many of the older films of India, you'll find virtually a remake of a Western film. But that time the rights were not that, asserted. People were not so conscious in asserting rights, and therefore they went by. Nobody bothered. Maybe somebody in Hollywood didn't even know what was a film made in India. But today things have changed. So very often now we find producers also much more conscious in obtaining rights. But what happens from the remade films? Like one of the issues arose in Delhi now, where a person gave a right to remake a film in Malayalam. Now, the film was made in Malayalam. There was no grievance about that. But then the person who made the film in Malayalam gave a dubbing right of his film into Hindi. Now, the Malayalam film is a different work altogether. It may be a remake of it, but ultimately it's a different work. He is not dubbing the original film, he's dubbing his own film. So, effectively, ultimately to a viewer, this will be something which is a Hindi thing. And that has been ultimately the court in Delhi has held, I think, that it is not a breach of the copyright of the original person, because this is only a dubbing of the Malayalam film, of which film he had a remake right. So these are complexities which to some extent need to be addressed in the law. That what is the derivative work? What is the right in a derivative work of a derivative work? Now, interestingly, Gauri just spoke of Singham, and that's because I think some stage we all have handled a matter relating to Singham and their derivative rights, etc. There is still an ongoing controversy in court whether the derivative right, if a derivative right of Singham 2 has been defined as being a derivative right of Singham, but whether the person has himself a right in Singham 2 itself or not, which was a pre-existing right, these are complex situations, and everything cannot be answered in an act, because how much ever you think, there will be situations which nobody has imagined. Therefore, you need to amend the act, yes, but not make it so watertight that with innovation, with change of situations, we cannot meet those situations. So we must have an act which will meet the needs of the growing times. So this is where there are so many aspects, but these are broad thoughts. And if there is any focused question on this, we could answer it. But anything else, Gauri, which you would like me to touch upon, I'll be happy to do.
I think the other aspect that often comes in the fair use is the parity, right? And I mean, how, because our act, if you see section 52, is not giving sufficient leeway to, sort of for us to take a view. So there are these situations where you are taking inspiration of something and whether it amounts to a fair use or not. So do you have any thoughts whether our act needs to revisit that aspect?
I really believe that fair use has been defined in a US statute. It's not defined in an Indian statute. Delhi High Court has, in one of the judgments of super cassettes, done a very good analysis of what could be a fair use. And I think that judgment is a very good guiding principle. And somewhere I feel that it is better not to give a very crisp and precise definition to fair use. Because ultimately, fair means an honest use for a purpose which is not competitive. Broadly, it means that which is not trying to commercially exploit the rights of somebody else, the goodwill of somebody else, whatever the reputation of the other film. And so long as that is the essential theme of what we do, I think fair use is something we should be left for a case-to-case basis. We could have a broad parameter in the act. And as I said, the Delhi High Court has done a very brilliant analysis of it. I was thinking of a situation where same use could be a fair use or could not be. And I was thinking that suppose there is a program on YouTube which is in the nature of a training for actors. It's a training course for actors. And they take a subscription charge. And in that, they show a film, a clip from a film, and then they do an analysis of that. And they say, just see how this actor has acted in this situation. See how this actor has acted in this situation. What is the difference? What are the analysis of it? It's a way of teaching the students. There could be another channel which says, which takes the best scenes, say it's a comedy film, he takes 5 best scenes from that film. And at the end of every scene, he says, what a brilliant scene. At the end of other scene, he says, hilarious. That is a comment. But his purpose is not to analyze. His purpose is to create a program where he shows the best scenes of that film so that people subscribe to his channel. Now that is not fair use. So therefore, you have to keep it from a situation to situation and leave it to be analyzed with the intent, the purpose, and how it is used. As I said, human ingenuity can have no answer. If we define it strictly, we'll find 200 ways of getting out of it. And it's good for us, but not good for the industry. So that's where I feel that it should be left a little fluid. We could have broad parameters and guidelines, yes.
Thanks for that excellent example. And sometimes you learn the law with these examples. Since Dr. Saraf needs to leave, if there are any specific questions for him, then we can take those first.
My apologies. Actually, I had lined up something at
No problem.
but
I think we have one question there.
yes.
So I have one question. Sir, we see a lot more copyright claims around the film production in the advertising sector.
In the
Advertising sector.
yes.
Marketing sector, advertising sector. Every day, somebody may post the advertising. I got to one or two every. So we have a month I commented. So, but there's no end result to already advertised content. Rather, it turns out to be a PR activity. I remember last 1 or 2 years ago, there was this ad, Hindustan Times ad on the front page, which basically said, one side there was a picture of Jolly LLP, the other side, there was suits, characters in suits, and they said there's some university that I don't want to remember, but said that if you appear and in our college, then you will be line cross rather than Jolly LLP. And it was a big PR activity. after, these film releases with Bollywood, he said that people need to apologize. Why is, Krishna a bad example? So, but it turned out to be a PR exercise later on for them, for the so-called university, to broadcast this for them that, this particular actor has gone on. So, what is the defense? What is the defense that the law gives us? Or what are the expected results that a person should have in that?
Okay, let me tell you, that's a very pertinent question. What you said is, what is the emergent action that needs to be taken and what is the end result? Because very often, as you said, the purpose is served by showing it. That person has gained the publicity. The difficulty lies in India mainly because the litigation takes that long to decide. And everybody knows that damages is an illusion which will take very long. Now, Delhi High Court in recent times has evolved a policy of, instead of going into a crystallization of damages till the end of the suit, they have been kind of granting ad hoc damages. So if we were to reach a situation where damages can be granted very expeditiously, that will be the only deterrent to a copyright infringement. Secondly, our courts, particularly the Bombay High Court, has kind of created a formula that if you come to court delayed on the eve of a release of a film, then you are not entitled to any relief. Now that, in my belief, is a too broad and over-encompassing kind of a thought process, because I have realized one thing: courts have held 2 months delay, 1 month delay to be too much of a delay. Now the film is almost on the horizon. But what about a script writer? He doesn't have a team of lawyers ready. He watches a trailer and he thinks, well, this is a script of mine. I had gone and told this producer this. And that equally for anything else, this delay part of it, if the court finds that the copyright infringement is blatant, if the court finds that the copyright infringement is something which is dishonest, then the court should, in my belief, stop that infringement at whatever stage. Today in Bombay High Court, you'll be surprised, we have had just 1 or 2 instances where after a release of a movie also the courts have said, shut it down, I am not concerned. You cannot do anything further. Now in a recent case, which I did, where there was a theater in England being made on that movie Disco Dancer, and they tried to make it into a Broadway play. We went in the last minute. The court said, fine, they are delayed and all preparations are made. I'll let these 4 shows go on. But bring in every penny that you earn from these 4 shows into court. Now, once we have actions like that, if a person were to say that, you need to bring about some response to this advertisement, I feel that if your advertisement has generated this much, deposit an amount of this much in court, so that finally this other person is secured as damages. In our country, the only deterrent that works is money. And that fear is an illusion, because you know that when damages will get decided, by then it's all over. Half the time the plaintiff loses interest, particularly small copyright holders all lose interest. So therefore, that's where the crux lies, and we need harsh orders, we need very strict orders to bring about a decorum of enforcing copyright. And once that is done, then I think we'll be having a much more stricter regime where people themselves will also respect copyright much more. And I must tell, before I leave, all my producer and the entertainment industry friends here, that we, as lawyers and judges, have a very firm, belief that whichever movies end up coming in court have not done too well. So please avoid that. No, in fact, it's a historical thing which is very well spoken of, to trace down the history of most of the movies which have come to court. This is, of course, in a lighter way. It doesn't do well. So that's something which we should keep in mind and try to resolve these issues before court, because court can be always a very fluid, fragile situation. And therefore, we need to protect our rights from day one, from the time we get a script prepared to everything. We are in an age where enough number of people just pop up from nowhere. just in the hope that I'll make some money. So it's extremely important that from the moment we conceive a movie, we do everything within our means to protect every step of our thing, of how we get a script made, how money is paid. Everything should be well documented and well protected. That is the only way I think that we can safeguard a copyright litigation.
Thank you. I think you have a couple of more questions if you have time.
Yeah, sure.
Yeah.
Yes, sir.
Good morning, sir.
Morning.
And this question is a rejoinder to the example that you quoted about a YouTube channel which kind of trains an aspiring actor on certain parts of or nuances about acting. Now, I come from the music industry, and it's been our endeavor to teach aspiring singers on the nuances of legendary singers of the yesteryears and about how they created music and what was it that made their music so special. So obviously this requires you to analyze the song, take it line by line, include all the parameters such as diction, expression, feel of the song, the raga, the framework, and all of that. So when you pick up a song of a record label and you analyze it in detail, and you were to coach an aspiring singer on those aspects, the question again comes up of the license and whether you can use, because the lyrics still remain the same, the raga framework still remains the same, though the coach may include parameters like innovation or you can always do a little bit more on the original work. You can add a few extra harkas, different things like that. But that apart, the structure of the song, the lyrics of the song, the main heart and soul of the raga still remains the same. So my question to you, sir, is that will that still come under the fair use? Because you're coaching a next generation, your wider scope is that you want to keep the legacy alive of the legendary singer and the yesteryear greats, whom we are now talking about being a Bharat Ratna and all that. You want to keep the legacy alive. So can it be considered as a fair use, and will it come under that, is my question.
I'll tell you, sir, what you say is so right. And in my belief, what you do, it will depend on the manner in which you do it. According to me, and I believe that, depending on each case and how it unfolds, you don't even need to add to that existing song. It will depend on how you have analyzed it. Now, suppose you take 2 lines of that song, you give it a pause, and thereafter, what you want to do is you tell the students, just see here, see this part. You are then analyzing the song. Now, suppose you show the full song, and after showing the full song, you just have a 30-second, 1-minute comment on it. Now, there what happens is the copyright holder feels that, see, I am showing this song on a paid channel. So instead of going there, people are listening the song here, then he will feel aggrieved about it. But if you want to say break down that songs into paragraphs or what you say Antara, Mukra and all that, play that part, analyze it, then come to the next thing. It can never subserve or harm the commercial interests of the other person. In fact, to some extent, he might be very happy that you have raised his song to an level of an example. So he might be very happy with it. So it's ultimately your intent, how much you have used it, how the extent to which you have used it, and the manner in which you have used it. Ultimately, your intent matters the most.
Thank you, sir. Thank you, sir.
There was one more question.
One question.
Yes, sir.
In relation to this query, but isn't that teaching also a part of this commercial activity, and isn't he drawing commercial gains out of that coaching?
Let's look at it this way. It is a commercial activity, but it's not a commercial activity competing with the commercial activity of that person. He is in a completely different commercial activity altogether. Now, what prevents you, let's take it this way, of taking a book and just analyzing it? Don't you have critics of a book? Don't you have reviews of a book? Now, what is he doing? He is basically doing something which would have been otherwise done in a classroom. Now, does it stop anybody from taking a book which was released 20 days earlier, a professor asking each of them to read the book, and let's analyze it tomorrow, let's discuss it tomorrow. It's a part of that. So he is carrying out a commercial activity, but not a commercial activity which is in competition or affecting other person's commercial interests. That is the crux. It's not that every commercial activity harms.
I think we'll take one last question. Yes.
Hi.
My question is that increasingly when our students make film in their initial semester, they tend to use archival footage from news channels or other places. Does that come in serious? Because we had a lot of issues later when we approached the channels. They asked us for money around 1,50,000, which is a zero budget exercise for us. And also when we make class in the classrooms, we do analyze films and use clips, as you said. But if we make those into online classes, that becomes a copyright issue, right? Or does that come into fair use?
I believe that, as I told him, it's ultimately the extent to which you are showing it, the purpose for which you are showing it. Why would a teaching on the basis of a anything? Suppose you are teaching students of how to deliver a news on television. You are training somebody to be a newsreader as a part of your class. Aren't you going to show him how newsreaders all over the world are talking? Without that, how will they be trained? So it's an essential part of the teaching, and the purpose is not to commercially capitalize on that news channel. Your purpose is to use that news channel for a purpose very different than a commercial use of that for a commercial purpose. You are using the whole purpose of a fair use. Means you are using it fairly, something which is not in competition with him. So as long as that is so, and if you have a look at the Delhi High Court judgment, it gives very good guidelines. It says, how much is it a substantial use? Tell me something, don't we, when you write an article, take an extract from a book and quote from it. You quote it, you give credit to that book. If you don't give credit to that book, it's a violation of copyright. But if you give credit to that book, then I don't see why it should be. Now, if you take an article and you just have an opening, the remaining is 20 pages of an extract from a book, and you have a conclusion. Now, that may be a copy. That may be an infringement of the copyright. But the extent to which you use it, the manner in which you use it, all that is relevant. And the example which you gave, if suppose you use a 20-second clipping or 15-second clipping from an archive of a news channel, and then analyze it in some way, or as a part of your article, if you could extract from a book as a part of an article and give credit to that, why can't you use that 10-15-second clip? I don't see any harm in that. Thank you, sir.
Thanks. I think interesting takeaways, from Dr. Saraf. Thanks a lot for your time.
Thank you so much, and my apologies for leaving because I just had thought it will get over by.
And I'm sure the college is going to soon invite you to give a more detailed lecture.
It's always these questions which leave us with a lot to think. Thank you so much. Thank you.
So, before you leave, I would request Professor Sadik Sheikh to kindly felicitate Dr. Birendra Saraf, Senior Counsel, Bombay High Court, with a sapling and memento as a token of appreciation.
Thank you.
Anil, now over to you and Pooja. So I think we had very interesting remarks by Dr. Saraf on the remakes and the and the inspiration and all of those aspects. And because you deal with these issues day in, day out, What are your comments in terms of when you look at Copyright Act? Does it give you any guidance when you're looking at, say, remake rights or a franchise right or a or something, somebody comes to you that this is only an inspiration, it is not a copyright infringement. How do you look at those aspects, both in terms of amendments required to the Copyright Act, number one, and second, if the Copyright Act is not giving you the answer, then in terms of deal making, how do you safeguard yourself?
So let me start by kind of looking at it from the perspective of operationally how we handle it. So when we look at copyright, all of us know that copyright only exists in the expression of an idea and not the idea itself. So there is no protection for merely an idea. So when we talk about inspiration, as long as it is an inspiration from a central idea encompassed in a film, which basically, if you look at 99% of the films produced in Bollywood, it would be revolving around 3 or 4 central themes, which is expressed in different ways. Like most of the films will have a hero, a heroine. There will be an issue which will be brought in by a villain, and then the hero basically overcomes all those things and rides into the sunset with the heroine. That is basically all the 80s, 90s movies, right? So, but it is expressed in different ways. So if you look at inspiration, it doesn't actually have a foundation in Copyright Act because it basically emanates from an idea. So as long as it is kept to inspiration, when people come to me and say that, okay, we have been inspired by this and we want to do something like this, I say, okay, it's absolutely fine. But we need to be sure that inspiration doesn't cross into the border of copying a part of that work and incorporating into this new work. Then that becomes an infringing work per se. So that is where we need to draw the line as far as inspiration is concerned. Now coming to adaptation. Adaptation basically remakes, dubbing, all those things comes into adaptation, the rights of adaptation, because adaptation is defined under the Copyright Act in a very straitjacket way. It only deals with change of format. If you look at the definition of adaptation, what do I mean by change of format? That's basically a literary work, basically a book being made into dramatic work or being made into cinematograph. So that is where the 4 corners of adaptation resides in. So if you are looking at a remake, for example, you take the rights in a book and create a movie out of it, or you have a movie which is already produced in a different language to be remade in Hindi language. So this all comes in the 4 corners of adaptation. Apart from adaptation, the main play that happens in today's world are in prequels, sequels, and spin-offs. Where do these reside? If you look at Copyright Act, you will not find any place it resides in the Copyright Act, because Copyright Act deals with only adaptations and the copyright of a work. Now, if a work, let's say the 4 corners of a work, when I say 4 corners of a work, let's take the title of the movie, the characters which has been built in the movie, and the storyline of the movie. The storyline, these 3 elements, that forms a foundation of a new work, basically like a sequel or a prequel. Basically the the story moves backwards or forward. That's what happens in a sequel or prequel, right? So the foundation for the new work is actually an existing work. However, the new work has more, it is 99% new original work with that 1% which is the foundation of the work, which in media or entertainment parlance we call it derivative. So it's a derivative of the original work, but it is not the original work per se, and it is not an adaptation of the original work as well. Now, there is no definition of derivative in the Copyright Act, if you look at it. But if you look at US Copyright Act and all, it recognizes derivatives. So maybe it is time for our law also to look at derivatives and give it an existence apart from what we see in contracts today. Today, if you have to go and argue a case of derivatives, it's going to be a tall order, because you'll have to explain to the court what a sequel, prequel, and derivative is, and how it forms it finds its foundation in an already existing work. Now, we have been faced with very unique cases as well, wherein the adaptation and derivatives overlap with each other. Like we got a right, exclusive right, to remake a particular movie in Hindi language. And along with that, we also have the exclusive right to make sequels in Hindi language of that particular book, which we have produced. Now, after maybe a couple of years, there was this sequel of the original movie, which was created by the original producer, and the remake of that sequel in Hindi language was given to a third party. Now, the question before law is whether that sequel, the remake of the sequel in the original language, transgress into the exclusive right that has been granted to us to create a sequel of the Hindi remake in Hindi language. So there are a lot of confusions that can arise out of this, which can be avoided. I won't say that it can be avoided completely, but can be avoided to a certain extent if the word derivative and the derivative rights find some mention in the Copyright Act and find some kind of definition under the Copyright Act. Now comes to spin-off. Spin-off is again a completely different animal from all of the other things that we discussed: adaptation, sequels, and prequels. What is a spin-off? Spin-off basically depends on two things. Actually, basically it depends on one thing. That's the character. Now, how a character, what is the rights in a character? How a character becomes a copyright is another interesting aspect of copyright. It can be built in two ways. One, through literally a character can be built, so then it becomes a literary work. For example, I'll give you an example of Dr. Watson from Sherlock Holmes. How it was only found in books, like before it was made into movie and all those things. It was made in books, created in books. So Watson has a limb, and that limb has a backstory. Watson is the aide to Sherlock Holmes. He's a medical practitioner. So this is the way his character has been built up. Now that character is capable of a spin-off. I mean, there can be a series only on Dr. Watson without Sherlock Holmes as well, because he is a central character in that particular story. A more precise way or more recent example would be if you have seen the series called Breaking Bad. There is a sleazy attorney there called Saul. So now we have a complete series called Better Call Saul, which is also running into many, many seasons. And in the original Breaking Bad, he was only one ancillary character, but he became so unique that the spin-off was possible. So this is a literal way of creating characters and spin-offs. Now let us come to the visual way. How visually a character becomes unique. So if you have a super hero movie where there is all superhero. When I say superheroes, what is the first thing that comes to your mind? There is a cape, there is a costume, there is a mask. Correct? This is the first thing that comes to your mind. But it's not unique. All superheroes are in the same manner. I mean, almost 90% of the superheroes are like this. But the moment I say the costume is blue, the cape is red, and there is a distinct font in a distinct font, S is written on the chest. Who is it then? It's Superman. Correct? So that is the way uniqueness has to be built into a character to be able to protect that character. And that character, when I talk about visual representation, it falls into the domain of artistic works per se. The other one is in the literary works per se. So these are two ways you create uniqueness for the character. And only when there is a uniqueness to the character, a spin-off becomes possible. You can see it everywhere, like even the series called Motu Patru that runs on our channels. There is an Inspector Chingam. Now the Inspector Chingam is a spin-off, and he has his own series. So everywhere, wherever the character is unique, you can build a spin-off on that. So this again is a completely different dimension to copyright. But all these things, I don't think we'll be able to. I don't think law can get into each of these things and protect everything. A lot of this has to be developed through interpretations, jurisprudence, and all those things as well. So
I think excellent examples, Anil, and I know that made me think what Dr. Saraf said and what you said. Even when we are talking about protection, right? One is what the law can do for you, and other things, what can you do for yourself? Just to give an example, when you create, say, a character, when you're creating a film, and if you believe that this can create a spin-off or this can create, some other property, is it a good idea then to sort of do some kind of a write-up, because you need something tangible for copyright? So you create a write-up, say, of a literary work, publicize it to say that, so and so character, this is that background, and sort of create that activity around that character, so that when you create a spin-off or otherwise, there is some essence that is already developed, which can be created, rather used for protection of that character. Because, we saw that, which was that film, Baby, and then you had that Shabnam or Shabana or someone, right? Now in that film, that lady was just there, right? But if somebody else had created, I'm just thinking aloud, somebody had created a film which is, a spy lady, right? Maybe look and feel similar. It would have been very difficult to protect that as a character, right? But if they had created a written description of, little bit things around her in advance, maybe then, you have something to sort of hold on to, right? And I'm just thinking, because of the examples that you gave, it's extremely important as to what you have created, the look and feel, as you said, right? The description of that look and feel, etc. So I think you mentioned about the Copyright Act in the US, and maybe that is something. And the reason I'm saying this again and again, because one of the key takeaways from this workshop will be, recorded by the DPIIT team here. So you are recommending that can we look at something that is in the US Copyright Act insofar as insofar as derivative rights, and think whether there's something similar should be considered for India. I think that is one key takeaway. And the other one is, of course, everything can't be under law. So you need to sort of, do something additionally on your side to create that protection. So I'll come back to you, Anil, in a bit. But over to you, Pooja. Two things that were discussed, and since you represent the talent, and there was a conversation about, the screenwriters, or, when they create something, we spoke about recording, with the Screenwriters Association or otherwise. So what is your general advice when you look at the Copyright Act? And the second one is when you are representing a talent, the point that Anil mentioned, a character. Now that character can be played by the same actor or can be played by another actor. So should the actor also have some IP attached? And I'm using IP in a very, very broad sense, but attached to that character, so that whenever a film is made with that character, the writers, that particular performer should always be attached to that particular character, right? So I think these are some couple of questions I have. And also, when you look at the performer's right under the Copyright Act, and then there is a conversation about, or rather a particular provision about when a commercial use is made of the performance, some royalty should be paid, right? So in the context of these rights that we're talking about, how do you look at that provision, if at all, whether that is relevant or not, and how do you look at it?
Sure. Thank you so much. I think a lot of points have been covered from a law perspective by Dr. Saraf and Anil. I think one point that I would like to bring, and probably break it up into your questions that you've asked. And when it comes to the first part of it, when it comes to just copyright law and writers at the SWA, what we always insist talent to do is every version of your screenplay that you're sharing with people, have it either registered with the SWA, so there is a trail, there is evidence for it. Or, as we all know, copyright, you don't really need a registration. You just need a proof or the date it was really created. So email it in a form to yourself, email it to a friend who you trust, and ensure confidentiality is maintained, of course. And keep paper trails of the scripts you have shared. A lot of times writers, especially younger writers, tend to share the script to multiple people across different production companies, right? So it's about just maintaining that database of who you have sent it, when you have sent it. And it's, as Dr. Saraf said very correctly, writers don't tend to have a team of lawyers protecting them. So it's only when they see a trailer, a lot of times, do they realize that, oh, I had sent this to them. And in fact, we had a situation where there was a litigation where one of the writers who had shared a screenplay to the production house, when they saw a trailer of a film on a platform, they sent a notice saying that, hey, you know what, this is copying my, it's very similar to my story. Luckily, the original writer who had actually created the work had a paper trail of her screenplay, which was registered with the SWA and shared with the producer before the date on which this was received by the production company. So it gave, I think what you take away is just a paper trail in a form where on the date on which the work is created, that comes very helpful. And SWA does handle such kind of litigations and has a board
in a panel basically which takes care of such litigations at their level. And it also goes back to Dr. Saraf's point on, the courts don't tend to watch the films together. In fact, if you remember, one of the projects, one of the litigations we managed is where the SWA actually watched the original film and the film in which that they were claiming it was being infringed from. And they went scene by scene, understood. And one of the reasons they said it's not similar is because the look, the feel, what you take away in general from both the films was so different. The way it was created was so different that you could not call them to be, one is infringing the other. So we do see the SWA at several stages doing this kind of things. And one of the takeaways is always keep a paper trail to the materials created. So that's, I think, the first point you've asked. The second was with respect to characters. And one of the examples which Mr. Anil gave is with respect to characters there are two parts of it, right? One is how, for example, a young Sheldon Cooper and a Big Bang Theory Sheldon, right? They are the same, and there is a personality characteristics to that person. It's a factor of not only how he is, but there are character traits to that person. And another example in our that I would drive slightly different is Shah Rukh Khan and his classic, his hand waving move. Some of these things, and from a performer's right perspective, you would always see that are attached to the performer specifically because it comes from that performer. And if that is being used in a way which is getting monetized, they should somewhere get benefits out of it. Having said that, if they are just the same character and there are no specific character traits, it's, in my opinion, still slightly gray. Of course, there's a recollection value of the audience as a whole to see the same person from one place to the other, which helps monetization. But you also see a lot of remakes today where the same characters were there, like Vikram and Betal and any of that, and you see different faces in different films for the same kind of characters, depending on the audience actually, and depending on the basically the cinema it's created for, like Bollywood or Hollywood or any regional cinema. So you see this in both the places where the same characters are played in remakes by other actors, and the same character in a spin-off is actually played by the same personality. Now in the West, there are rights, like in the US, there are rights given to such characters, such performers, and it's very clearly articulated as to monetary compensation for them. However, over here, you do not see that. There is, and somewhere it stems from the fact that these derivatives are actually not recognized under the law as spin-offs. So they do not get the monetary benefit of it. In fact, in the West, there are also, every time the content is screened in a different medium, they are getting paid a certain amount of royalty. If you see Friends being utilized on OTT channel versus a satellite, there is compensation going to the performers of it. So these are things which we don't currently have in our law, our rules, or there is no association which clarifies or does defines this, which you see somewhere in the music, where if there is utilization of the music in different formats, they are getting a certain amount of compensation. So I would address that point and probably going back to even writers and commercial use from there, or directors. If there is an original IP that is created or a character that is created, if I may put that way, you do tend to see again in the West that there is very clear monetary compensation requirement of providing credits for these kind of characters or this kind of screenplay or script, which you don't see in the law over here. So these are points we generally try incorporating in contracts. A lot of times when there is original IP created, there's a lot of commercial and legal conversation around derivatives, spin-offs, who gets compensated, at what stage they get compensated, or if they get credit or not, because that's a very important part of the creating process for a creator. So what the law is not solving, and Mr. Adil can also agree, there are long-run negotiations around this when it comes to protecting the writer, protecting the performer from a legal perspective in a contract. So.
Yeah, I think, so what I'm understanding is, there are certain aspects, ultimately the industry or all the stakeholders in the industry need to decide what should be left to the legal sort of recourse and what should be left to the contractual negotiation.
Absolutely.
And there are two school of thoughts that let the guilds, the guild system develop in India for this purpose, and then let it be left to the to the sort of bargaining power of the guilds, rather than the law defining the commercial aspect. So one is the commercial aspect and second one is the first is the legal aspect and second is the commercial. So maybe the law can determine the legal aspect, right? But the commercial aspect should be left to the guilds. Is the thought process typically I see work. So do you both agree to that?
I completely agree that wherever law tries to kind of reach into the commercial aspect, it always leads to a lot of confusion and the system always kind of breaks down. We have a lot of examples we have seen otherwise as well on that lines. So I completely agree. I mean, whatever examples Pooja was also giving was about the guild in US and how they operate and the guild contract standard formats and all these things. But in India, even the royalties and all those things is going through a lot of issues right now, the mandatory royalty sharing and all. And we are now ended up with Honorable Justice Sandhya's judgment and looking at the way forward from there. So
yeah, in fact, we do have a separate session on music royalties, because if we talk about performers here, what gets determined under those will ultimately affect the performers' royalties as well, because of the unique position that we have under Copyright Act.
True. Again, I slightly differ on the performers bit because when you look at performers, any kind of work that is created, it's a literary work, lyrics is a literary work, musical compositions is a musical work. All those things are works that are created. Performers are performing that work. So that performance being used in a different manner, yes, absolutely. But if there is a remake or something like that, and where a different actor comes and performs the same work based on the literary work, that would be
absolutely not. No, but I think the difficulty that we have is the section 39A. Though this provision is not affected, yeah. So that the way they have just simply just as addition, they have just put in the act, this 39A, which creates a tremendous interpretational issues. So I think that is one aspect. Probably also we need to revisit as to what issues get created because section 39A. And because of that, how at least for the singers, performers, and the others, which are working under the direction of somebody else, they should be looked at differently or not. I'm not passing a judgment here, but I'm just putting a question across. So do you both agree that 39A needs to be revisited?
I completely, and there are a couple of other clauses, sections also I would really love the government to take a relook at.
So you could probably, both of you could give your suggestions, and they will consider that, the team will consider that for their report, because as I said, after this workshop we will have a report coming out, so you can even give your written recommendations. But over to the audience now for quick questions, because we have another one small session which is on a very interesting topic just before the lunch. But yes, over to you.
My question is, do you feel that somewhere we are still yet to come on the legal definition for artists? Is it somewhere, is that chaos started somewhere there? Where we are yet to, sorry.
Legal definition for what?
A legal definition for maybe artist or performer or recreator. Because the one thing which I'm feeling in this particular matter is when it comes to all of these discussions about who holds the right and who is who and who is what. In terms of legalities, we have to literally define that, oh, this is orange, it looks like this, it has this kind of a shape. Have we reached to that stage yet where we can definitely say, oh, this is the legal definition of artist, this is the legal definition of a screenwriter? Because there is a vast difference when it comes to Oxford Dictionary and an Indian dictionary, and there are multiple different ways of putting these things out. So if that is, if we can put a little bit of light on whether there is a legalized definition to it.
So if you look at the Copyright Act, there are works which are defined.
That's the problem, I think.
No, so we need to find out I don't think under a particular law you would be able to take each and every nomenclature and define that. That would be like, that may not be a very useful exercise from a law perspective. If you look at the works, it is the literary work. When you look at literary works, it encompasses anything that is written. Now that can be written by a writer, right? As a writer of a story, writer of a script writer, it can be a screenplay writer. So all of them are writers at the end of the day, and they are creating either literary work or a dramatic work. So as long as they are creating one of those works which are protected under Copyright Act, they all come under that definition of the writer, as in who is a writer or author. I will call it a writer, author. So who is an author is defined, and that author, whoever creates that particular work, gets the protection as the first owner of that work. So that way, I think Copyright Act internationally also we'll have to look at how it works. Internationally also operates in the same manner if you look at it. It's an author who is the first owner and rights holder of that particular work that has been created.
And I think what we go back to is how much can the law define something, and how much do you want it to constrict someone from being able to function, right? When you say author, it's actually pretty clear. Literary work is pretty clear from a law perspective. It's for us to interpret it, and it gives you that little canvas to play with it. If you tend to constrict it this much, then it may be very difficult, and then at every point you don't have that room for interpretation and have to go to court. So maybe this little openness helps from the perspective of the industry as well. Unless you have a specific example as to where this has happened and why you would require it. Of course, there are some instances where there's lack of clarity, but broadly, it's pretty clear today on these aspects of it at least.
Okay, so I mean, see, a lot of the times in this particular industry, there are multiple types of writers. There is the author of a story, then there is a screenplay writer, and there is a dialogue writer. There are many writers associated with one concept or one theme played. And eventually, because it's art, everyone says that either it will be based on Ramayana or it will be based on Mahabharata. So there is a different author to that as well. So what we are doing is obviously the expression is something which we are trying to cover under this.
So I think you're broadly talking, as GT also correctly said, is more from a writer's perspective and what are the different forms of writers, as you're saying, as the one who actually made the remake or you made the original work. So I think that goes back to the fact of, and again, a little bit of interpretation, because then it gets grey when there is a writer who's written the screenplay, but there's an additional writer who's come and fixed that screenplay. Then there's a dialogue writer who's further gone ahead and written it. A lot of this is industry parlance and goes back to somewhere the concern only arises in two places, right? One is when you have to be given the due credit for it, or when the royalty is also attached to the credit aspect of it, and the second is commercialization or what needs to be paid. And somewhere the second part of it is a factor of negotiation, and the industry bodies can help. And the first part of it also somewhere we see SWA step in internationally. We do see this clarity given in the WGA's arbitration mechanism and clarity of credits as to who does what. So goes back to the first part we were discussing, is maybe the law is there, but the industry bodies need to probably, the guilds need to probably help in clarifying it in the event of a confusion.
Okay.
No, I think the question, as you rightly said, will come down to two things: credit, which is contractually maybe parties can agree, but the moment, and there is still debate whether the script writers should be given royalty or not. So that debate I'm not going to get into, but the moment if that is recognized, then the question will be who amongst them, because all have contributed to that, who amongst them. And then whether it will be determined again by inter se contracts or otherwise, right? So that is where we will need to still wait and watch this space because there's still a gray area on that. In fact, my first mentor on IP, very well known Professor Daruwala, he used to always say that copyright is, among all the IP laws, copyright is the most abstruse law. So on that note, probably we can end this conversation unless there is another question, but we will be quickly moving on to the next session, which is on the NFTs, which is a new upcoming area. Yes.
Film is based on drama, adapted. Drama has certain dialogues. Or even pathology films are without dialogue. They are kept as such as they existed. Then who will boldly copyright and copyright?
So you are talking about drama like Bhagavad Gita, Ramayana and all.
No, all drama, is social drama converted into film.
So it's an
There are dialogues. It's a dialogue that we come in the film also. Then how they write between silence?
So the question here, there are two questions I'll have to ask to respond to this. First of all, are these dramas, social dramas, which is part of folklore and all those things that you're referring to?
Drama as
And books which are modern ones or the early ones, old ones. So why I'm asking these questions is to understand whether we are talking about things which are come into public domain by effects of time. Then obviously it's in public domain. Anyone can create on it. But if you're looking at drama that is contemporary and it is written currently and it's a play, basically that's what we are referring to, then it is a clear adaptation. It's a change of format. It's the adaptation from play to a cinematograph film. So comes under the definition of adaptation under the Copyright Act. And for that purpose, let's say we as a studio is going to adapt a play into a cinematograph film, we have to approach the writer who is the author of that play and obtain the rights for the adaptation to the cinematograph film. So this has been done actually in my earlier organization. We had approached a lot of playwrights and taken rights to create a cinematograph film out of, as in the playwright, the drama which is on stage, which is recorded and made into recorded films. So there were two distinct rights in this one, wherein the playwright continued to exercise his right to perform the drama on stage, wherein the recording of that and the cinematograph, the creation of the cinematograph film and performing or communicating that to public on our platforms was exclusively given to us. So this becomes two distinct things, or I mean two distinct rights. Did I answer your question?
Yeah.
Thank you.
Then the original dialogue writer in the drama.
Yeah.
Does he have some rights in the same?
Of course, he will have. He's the author of those dialogues. So that is part of the literary works, and yeah.
Yes. Can I ask my question?
Sure.
So how do you deal with, so you have these lot of cartoon characters which kids like. Now with all those YouTube shorts and Instagram, that kids are made to say these dialogues in say 15 seconds or 10 seconds. So how do you deal with that?
So again, we come back to fair usage and not fair usage, I would say incidental usage there. So it depends on how it competes with our rights and our monetization of the rights. If it doesn't compete directly with our monetization of the rights, then we consider it as an incidental usage. And we just move forward from that. So that's one part we did not discuss about is the incidental usage, which also comes under the legal doctrine called de minimis non curat lex. Basically, law does not deal with trifles or trivial matters. So there is a lot of jurisprudence on this particular point of law as well. And I think Dr. Saraf mentioned about it, as in the exact 5 words which is used in a particular, let's say, for example, in a program, 5 words of a song has been used in a program, that may come under de minimis usage. But those 5 words, exactly the 5 words, if it is used as a tagline of an advertisement commercial, that may not come under a de minimis usage, because it basically, otherwise the owner would have to be paid for the usage of those 5 words. So similarly, in our case also, where if it is a kid using for one small part of it or one dialogue out of it, it is not exactly competing with what we are doing. But let's say there is a complete part of our soundtrack being used as the background of that video, then it would be competing with what we normally exploit or sell. So that's where we would get into an infringement claim or something like that, or copyright strike on YouTube.
Thank you. So I think unless you have any sort of closing remarks, we'll close this session, but quickly move on to the next one. Is it okay if we continue for say 10-15 minutes? We just maybe I really want to share on the NFTs. We had done quick fireside chat on NFTs. If you have time, then we could quickly move on to the next session. So with your permission. Thank you, Pooja, for your time.
Yes.
I would now request Dr. W.N. Dumane to kindly facilitate Mrs. Pooja Kapadia, Head of Business and Legal Affairs, Tulsia Media Private Limited, with a sapling and memento as a token of our appreciation.
Thank you, Pooja.
So again, I would request you to also facilitate Mr. Anil Allen, General Counsel, Viacom 18, who is a lawyer by profession and postgraduate in media laws from National Academy of Legal Studies and Research. Thank you, sir.
So we thought as a part of this discussion, though not strictly on Copyright Act, but it is linked to Copyright Act, is a discussion on NFTs. And Anil, I know since you have handled recently an NFT transaction, we thought maybe a good idea, since we are going to have industry members here. And of course, some people are joining online as well. So for the students also, it will be very interesting to understand what is this NFT in the, and of course, people may have sort of traded into NFTs from the audience. But what in essence is NFT, we will discuss that. And then we will come to the rights as to how we look at from a Copyright Act at NFTs, and also what are the benefits that the creative community can derive through the NFTs. So maybe these 3 points we will quickly take. So the first one, if you sort of quickly explain what we mean by NFTs in the context, in relation to an artistic work or a literary work or say a video clip, because there can be NFTs with respect to multiple other assets, but let's just focus on the copyrighted assets.
So when we say NFT, as we all know, the word means non-fungible tokens. It is just a way of, attributing a sense of ownership to a particular digital asset. So it is based on blockchain, where once a record is created, you cannot change it. So when it comes into the entertainment domain or the artistic domain, that means any kind of artistic work or clips from a cinematographer, sound recordings, all these things can be created into an NFT. For example, we have now MTV NFT is called Fully Faltu, which basically is not that faltu, but in which ways, it's basically images that's been curated and created to be minted into NFTs. So the whole landscape of NFT actually will become more and more important when we go ahead, because it's all about digital collectibles. Earlier, we used to see that basketball or not baseball, basketball cards in the US and all, that could be collected. It used to form as collectibles, and but the genuinity of that particular card was always suspect. Now, as a digital asset, the same card, you don't have to have a problem, because on blockchain, the ownership or the verification by an NBA or all those things would be available on the ledger, on the records. So that's how the NFT comes into the artistic domain or the copyright domain, where artistic works can be minted into NFTs. And with advent of metaverse and all, even today in gaming and all those things, NFTs are created using art, gaming collectibles, like your characters or what the characters wear, the shoes that they wear, the dresses that they wear, all those things are becoming more and more NFTs, because you can, even after the game is played, you can retain that as a collectible. And the value of the collectible changes according to the demand of the collectible and the scarcity or the availability of the collectible. So that is where generally when we talk about NFT in artistic domain, generally that is what's happening.
Thanks for simplifying it, because many people still get confused what exactly is an NFT, and you very simply have put it as a collectible, because ultimately it's a bragging right that you're having, that I have this, these NFTs are scarce and I have that ownership. And just to clarify, the ownership of an NFT in relation to a video clip does not mean I own a copyright in the video clip. I'm simply owning a signed version probably of that video clip, right? So there is always that confusion that am I owning, can I do anything with that video clip? And then of course depends on the smart contracts. So when you're talking about, you mentioned about say a video clip NFT. Now suppose a talent which is appearing in that NFT, say Shah Rukh Khan is appearing in that particular video clip, and you're creating an NFT. If Shah Rukh Khan was supposed to sort of get some kind of benefit of each sale of that NFT in the market, is that possible, and how can that happen?
So I think it depends on the contract that the artist will have with the particular creator of the cinematograph film, because cinematograph film per se is a work defined under Copyright Act. And if again the cinematograph film, when you see it on the movie halls or the screens, it is just a cinematograph film that you're seeing, but the pyramid of rights that is behind that cinematograph film, the restrictions, the rights, restrictions, holdbacks, all those things are a complete, what do you call it, it's a web. So when you enter into an artist, especially like Shah Rukh Khan or someone, he would obviously reserve his personality rights, as in the usage of his personality rights can only be for the purpose of the cinematograph film to be shown in or exploited in certain manners. And he may put some fallbacks regarding clips being used, or if the clips are being used for merchandising. Otherwise, an image of Shah Rukh Khan, just because he has acted in one of the films, can be used on t-shirts, right? So that basically goes into the domain of personality usage. So all those things comes under the contracts which we enter into with the artist and are normally reserved by the artist, and where we need to take it for certain purposes like merchandising or NFT. Sometimes there are premiums that we take out when the movie is releasing. If the character is in a specific form, like for example, an actor who has acted as Wolverine in X-Men. So in that format of Wolverine, or in that character, the NFT may reside with the studio or whoever has to take it out in that particular format. But as a normal person, as a normal actor, the NFT may still reside with that. But again, it all comes back to, boils down to the contracts and not exactly on copyright or any other rights as far as the artist is concerned.
Right. So I think even the way the smart contracts are written, we understand that if a performer or any singer or whoever has contractually agreed with the producer that every exploitation I will get X percentage. So because it's a blockchain based phenomenon, it can actually be written in a smart contract so that every sale automatically remits that much money to all the stakeholders who have those basic rights. So
only problem is that it will have to be cryptocurrency.
Yes.
Otherwise, automatically it won't.
So I think that is the other thing. When we look at copyright now, we can't look at it in isolation, because a lot of these things that are developing in terms of monetization over the internet or the web or Web3 that we will get into metaverse, a lot of things will get attached to the cryptocurrency or digital currency as a whole. And therefore, if at all some of these new models have to flourish, we will also need to see that it can't flourish unless you have access to these other digital aspects. So, yeah. So your recommendation seems that you should also consider how do we sort of give validity to, and stability to cryptocurrency in the country.
I don't know how. That's a very beginning.
Yeah. No, the point is because the NFTs from an artist perspective, it's going to be very beneficial because it will disintermediate, all the copyright societies or otherwise, if you really see, at least in the digital scheme of things. So can you just visualize that if a talent wants to sort of capitalize on the copyrighted material that it has created, how do you visualize that the right, all these rights can be, right holders can be given their, fair share, on, at least on the digital exploitation?
No, as you rightly pointed out, Gauri, the best way to do that would be through smart contracts, and I think that's the way the future is going to be paid. Where the smart contracts, wherever there is a right that is being exploited, or even today there are royalty collection societies which are formed. They are supposed to distribute revenues downwards, but there is no even uniform database of a music usage system in India today. And we don't have a capability of reporting any of the music usage today to even a copyright society, because we don't get music usage. Even labels who keep music usage, they keep it in different formats. So an AI-based system is not even able to understand when we have a music used in one of our programs. And why I'm giving this example is because we are in this space and we are talking about smart contracts, where we are looking at blockchain. We are looking at smart contracts built through blockchain. We are looking at each and every transaction happening through that smart contracts, where the smart contracts recognizes that this transaction has happened and executes a payment that goes automatically to the artist, performer, or whoever it is. So, even a copyright collection society kind of society may not be required if all these things functions properly. As in, it can just execute and say that, okay, this music has been played 100 times on this particular OTT platform. This is the pool of money which is supposed to be the royalty. This goes to this 10 artists, because these 10 artists' songs are the ones which are played the most. Vis-a-vis today, no one understands whose music has played where and how much it has been played for. So I don't even know how the royalty system is actually and practically working on ground, even if the societies are able to collect royalties.
That's a very, very, valid point. And, so because a lot of conversation was, in the morning was about how technology is creating, a lot of issues in addition to benefits. But I can see this can be a clear benefit where we can deploy technology for, the entire artistic community, or rather all the stakeholders, including the producers. One last question is on the mode and medium concept under the Copyright Act. And how do you look at the digital exploitation, especially in the context of NFTs, and whether the way the law currently reads on modes and mediums, just with this NFT example itself, whether it's something we should take forward, or we should revisit the concept of modes and mediums assignment?
Thank you so much for asking this question, Gauri, because this is one of those things that I was referring to earlier, where I hope the government takes a relook at. So one thing that I found very strange is that modes, mediums, and formats under the first proviso to section 18(1) says that if on assignment of a copyright, if there is a mode, medium, or format which was not in existence or commercial use at that point of time, then the assignment doesn't apply to it unless and until it is specifically mentioned in that contract of assignment. Now today, let's leave today, because today you will say that I'm talking about the future. Let's talk about the past, how it has worked out today, till today. Let's say this law was passed at the time of VHF cassettes. The cassettes, I think some of you may not have seen it also, but the cassettes which we used to watch movies on TVs, right? So those cassettes at that point of time, let's say I'm a producer, I went and took the home video rights, and this law was there. Let's take that for an example. I got the home video rights. CDs, DVDs, Blu-rays were not invented back then. I get the rights. Tomorrow, CDs comes, VHF goes out of the window, but I still have home video rights. Does that mean the full term of copyright for that particular right that was granted to me is now extinguished? Whatever I paid for is gone. Because why? There is a new mode of exploitation. So that is gone, new thing has come in, and I don't have a right. If I have to get the right, I have to go back to the owner, take that right specifically. And DVD goes, CD goes, DVD came, DVD goes, Blu-ray came. So all these things are actually replacing technology. And today we are looking at multiverse, right? Metaverse. And we are at the age of OTT platforms reigning everywhere. Tomorrow, the same OTT platform may cease to exist in a 2D format. Everyone will be watching the same thing on a metaverse on a virtual reality format. That doesn't mean that all the rights that we have taken based on internet, based on 2D format on internet, completely gets extinguished. So if that is the case, most of the OTT platforms would go out of business. So this is something, I mean, again, NFT is a new thing that's coming in. So till today, what was being sold as pictures, image rights that we have taken. NFT was not part of it, or digital image rights if I had. And just because an NFT gets attached to it, does it extinguish my digital image rights that I paid for? So all these questions need to be answered, and this particular proviso to section 18.1 needs to be relooked. Otherwise, it really and directly impacts the commercial exploitation of people who are investing in this industry, which is not an encouraging factor for people who are looking at future investments.
I think it's an excellent issue. I mean, the way you have put it across, because when the law probably was looking at modes and mediums, they were contemplating that additional will come in, not replace. The moment you are replacing, the earlier right word loses value, right? So if it is replacing something, then you can't say that, that these are additional rights where the underlying rights owner should benefit. And most of the technological advancements will be replacement. It's very rarely that you will have to, two things working in parallel, right? So I think that is one other aspect I would recommend that DPIIT cell notes is with this specific example that Anil has given. It will make life easier if it is like a bundle of full rights, and then it's a matter of commercial negotiation between the parties. So leave it at commercial negotiation. And we say, okay, any mode and medium gets attached, then you get an additional royalty, or otherwise that's a commercial discussion. But there is no question mark on the right? That is where the ownership.
It just goes to the base of the whole concept of ownership.
Absolutely. So yes.
I have one small question. You are already focusing on the music and the creative industry.
But there is a bigger NFT option opened visibly during FIFA. In last 4 days, 100 hours, over $30 billion of NFT origination rights have been signed on paper. How many will actually happen, one doesn't know, because all the countries who have lost the game may not be interested. But at least 4 or 5 top ones will emerge. And like in India also, not to talk of FIFA, Gavaskar and few players have already engaged into NFT. Like there are few other non-media entities. I'm saying sports is another kind of thing. Then there is a knowledge NFT also. So why are you limiting your viewpoint to this? And I can only tell you that I was the first general manager in Walt Disney in '93. And Walt Disney left India in '94 because there was no IPR protection in India, and went to WIPO to learn. And I was the first Indian to have attended WIPO in Switzerland. But the truth is that with half knowledge and with partial understanding, we should not encourage into the deal. I think our honorable speaker mentioned about convergence legislation. I am the co-author of that from ASSOCHAM. I was chairing ASSOCHAM Media and Entertainment Committee. I also did the IT Act in 2000 with them. But the whole idea is that even during a parliamentary subcommittee session for IT Act and IT Act modification in 2007 or 8, people were unable to understand what is called cyber. So for them, cyber is like a word from Khyber. I mean, it is a joke, but not like that. But the issue is that how cyber or how future technologies like quantum computer, every protection system in cyber today will be broken in less than 1 second by a quantum. So I'm not talking, but let's talk of little bit larger perspective of NFT. Thank you.
Thank you, sir. So I appreciate the large experience and wide experience that you possess. I was talking only about entertainment industries because of the title. that we were only referring to. Yeah. So that's why we were. No, I completely agree and understand and acknowledge the fact that NFT is not just limited to entertainment industry. It has a lot of wide usage, and more than that, NFT relating to artistic work was the theme of the conversation. But apart from that, NFT actually is going to be useful. I mean, I really hope that this comes into play is where land records are also NFT. So if today, if you have to go and buy a land, you have to go and check 30 years of mutation records. If it is NFT, you just have to do it. You can get the whole verification diligence done in one click. I'm sure a lot of lawyers will lose a lot of money with that, but still, that would be a great thing to see. If you start talking about that, there is an ocean of stuff, futuristic things that we can see what NFTs can do in metaverse. For example, most of the stuff will be working on NFTs and AI and all those things. So that conversation, me and Gauri have had this kind of conversation, and it just goes on, and it's hard to limit it in the 15 minutes we are having right now. Thank you.
Thank you, Arun, for your time on this. And with that, I call the session to close the first half, and we will resume for music, and that is going to be more engaging in so far as the complexity are concerned. This was still easy. Music is.
I'm glad I'm not part of it.
Neither am I. So that is going to be more complex to figure out, and we have very interesting panel members. And of course, the last one is on piracy and copyright infringement, where we are going to have somebody from the law enforcement joining as well. So stay tuned, and we'll be back.